Texas doctors get new guidance for when a woman can legally get an emergency abortion.
At the end of the day, it is the physician who is going to render that final recommendation and that judgment on how to act on a given scenario.
But not everyone is satisfied with the decision. We look closer at why some believe the rules could put women at risk.
That one alert at the right moment for the right person might save a life, so why not?
Years after its creation, an active shooter alert remains silent. Why one lawmaker says it comes down to a change in procedure.
It's time to stop ignoring this issue or dismissing it as someone else's problem. As you can see, this can happen to any of us.
Stories from victims calling for new steps to block explicit images created by AI. Now a Texas senator spearheads a new bipartisan bill.
Produced from the Capitol in Austin and airing statewide, this is the award-winning State of Texas.
Hello and thank you for joining us. I'm Monica Madden, in for Josh Hinkle. The Texas Medical Board unanimously approved new rules giving guidance on when doctors can perform emergency abortions legally in the state. It's an effort to clear up any confusion over what is and isn't allowed, but the board did not provide a list of conditions of when doctors can provide abortions, warranting criticism from some. Here's a look at those guidelines. When and how doctors can perform emergency abortions in Texas has been contested for years.
Then they've established a whole set of such severe penalties that it's created this chilling effect, and no one wants to be the test case. I don't.
On Friday, the Texas Medical Board adopted new guidance for how physicians should interpret the state's abortion laws, but acknowledged their limitations.
There are certain things that we can address, and there are certain things that we ultimately don't feel that we have the authority to address.
The rules outline how the board will look into alleged illegal abortions. They added guidance reiterating a Texas Supreme Court ruling that said doctors do not have to wait until a medical emergency is imminent before terminating a pregnancy.
If a woman's life is in danger, there is no uncertainty there.
The panel refused to list specific medical exceptions to the law.
The concern with a list is, what if a situation arises when something is not on that list?
Joining us now are attorneys and lobbyists Steve and Amy Bresnan. They are the attorneys who originally wrote the petition to the Texas Medical Board. It sparked this entire rule change, and I'll preface that both of you were not lobbying on behalf of a specific client when you wrote this petition to the Texas Medical Board, asking them to clarify when doctors could provide an abortion to women under the medical exceptions clause. So first and foremost, I just kind of want to highlight, what was your original goal when you filed this petition, and do you feel like you got anywhere near that goal?
So our original goal was to obviously make the situation better with whatever tools we had at the time, because the legislature is not going to be in session until January. The Texas Medical Board was really the only avenue to seek immediate relief for women who find themselves in this situation. So we wanted to make sure that any improvements could happen immediately with the Texas Medical Board. That was our original goal. Where do we think that we are now? There have been some slight improvements. However, we are disappointed. We don't think that doctors will feel any more comfortable providing abortion care where it's necessary under the statute, which means that women are they're not as safe as they were before or after these rules were adopted.
Now, I want to talk about the documentation provision. Of course, now doctors, after performing an emergency medical abortion, will have 7 days to, fill out this documentation explaining the reasons for that and, what they thought, why it was justified. However, one of the controversial provisions that was kind of being discussed during all of these board meetings, Steve, you found was still in there somehow.
Yes, it was a documentation provision under the proposed rules that would have required the physician to document whether there was time to transfer to a, quote, higher level of care in order to avoid an abortion. None of that appears in the statute. It has nothing to do with the abortion exceptions. They took that out of the documentation part and put it over into the part where what a disciplinary panel should consider. At the meeting, they said they had taken it out, but it's over now, it's in the disciplinary part. That's an upgraded, if you will, standard. It's a lot less of a being implied as it is being made more substantive and direct. That's moving backwards.
What does the path forward now look like for you?
Consulting the lawyers who work actively in the administrative procedures law as to whether the law requires this rule to be republished, so there'd be more public comment on it.
We do think that this rule is required under statute to be republished because there were substantial changes, and under statute that means that they have to give the public notice and seek comment.
One of the good things they did was said she doesn't have to be at death's immediate door, and so that'll give physicians a little more space to operate in. But we think that those things combined are substantive enough changes. The public got no notice that this transfer provision was going to be made more substantive and less just a matter of documentation. It's important that we not talk about that in esoteric, legal terms either. This means delay. If the physician has to find through any means necessary where a higher level of care, whatever that means, might be, and then get her there by life flight, by car, by train, by whatever, you're talking about delay. Somebody with a life-threatening condition who's already met the standards of the statute then has to wait
in order
while this physician tries to meet this implied duty. It's a serious matter that has practical application for patients.
And based on what some of the stakeholders have written over the years, it's clear that the transfer provision says in order to avoid an abortion to a higher level of care. In normal speak, what that means is it's going to cost more. So they're going to transfer a woman to a higher level of care, keep her on antibiotics, bed rest until her pregnancy is far enough along that they can perform a C-section on a non-viable fetus, which is extraordinarily more expensive than an abortion.
All right, that's our time for now. Amy and Steve Bresnan, thank you so much for your time today.
It's really just about protecting my child.
A new bill taking aim at pornographic AI imagery. How the story of one Texas family is pushing one lawmaker to take action. Did you know there's an active shooter alert? Despite mass violence events across the state, an alarm has never been sent out. A state lawmaker breaks down the confusion over the procedure and the change she wants to see over the system.